now, the High Court in Cape Town has found that the Western Cape's school admission system is unfairly discriminating against black and marginalised pupils. The case was launched by Equal Education and its Law Centre, which argued that pupils in areas such as Khayelitsha, Kraaifontein, Kuils River and the Strand were affected. The group's Yolisa Piliso joining us now for this particular engagement. Yolisa, good evening to you. Thank you very much for your time. The court rejecting the Western Cape Department's narrative that parents are responsible for the late applications. Explain to us in a bit of detail as to what these pupils are faced with.
Good evening, Tali, and good evening to the viewers. So firstly, I think for the grounding of the context in this matter is the reality of many learners in the Western Cape at the beginning of every academic year continue to be left out of the schooling system because of failure to maybe get like school places. And this comes as a result of over subscriptions in schools. And the failure to plan by the Western Cape government to ensure that there are enough school places for these learners. But what we've seen as Equal Education over the years, and now we've been engaging with the Western Cape government, is the denial of the systemic challenge that exists in the province, and the shifting of blame towards parents in relation to applications for seeking school places. And the court has placed it really in record clearly that this is the responsibility that lies both on parents and also on the department. But the excuses that the department has been making is the fact that parents are applying late. And that is exactly where our challenge was grounded on their policy in as far as it doesn't deal with the provisioning of school places for late and extremely late applications in the province.
And so the Western Cape Education Department now is being forced to take a proactive stance. So what is it that they are expected to do from here on if they are to be in line with what the court has instructed?
So firstly, the policy itself that the Western Cape Department is using for the processing of late applications is a policy that we have engaged them on in relation to the gaps that exist on it. And over the years, they haven't been coming on board in relation to the reviewing of that. But because of the launching of this application, there has been at least some way forward in which the Western Cape government is agreeing to the process of reviewing its policy and consulting parents, Bazali and learners from communities as far as Khayelitsha, where all of these realities are really entrenched. Because the policy in itself and the effects thereof are not only are mainly felt, in fact, by the communities of Khayelitsha and many other marginalized communities. And this is a result of the reality that we've continued to see over the years. And this is something that the court has also affirmed, that because of the existing norm around the customization of people in terms of when do they relocate to different provinces. And this is what the judge said in relation to this, that it's more in relation to people understanding as a result of apartheid, where that we are only moving to different provinces to seek opportunities in times where like it's January, late December, and sometimes February. But the Western Cape government hasn't been making provision for these realities, and they are deeply entrenched in the system. And what we now also will be seeing, at least, is the process of reviewing of the policy and with the consultation of all stakeholders in education in the province, and ensuring that the policy upholds the right of learners to education, upholds their right to dignity, and ensuring that there's equality in access to education in the Western Cape.
Yeah. Very briefly, the department, when we knew now on the program that we were going to talk to you, we got in touch with them to say, we would like you to also come and respond for yourselves. But they declined this particular platform, but sent a written response to us saying the following, and I'd like for you to respond to it. And it goes, the dissenting judgment states that the main judgment is, quote unquote, flawed, and that the admissions policy, and I quote again, does not discriminate, let alone unfairly so, on the basis of race, poverty, place of birth, and social origin. So they seem to rely on the fact that this was not a unanimous judgment and that the dissenting parties were clear that this is flawed and certainly does not discriminate on the basis of race or poverty, including places of birth, etc. How do you respond?
It wouldn't be surprising probably for the Western Cape government to cite that only part in terms of their response to this issue. And I mean, it favors their position in terms of how they've carried the narrative around their lack of planning, ensuring that there's enough school places for these disadvantaged and marginalized communities in the Western Cape.